Welcome back to Legal Lens Zimbabwe, scholars. In our previous lecture, we looked at what a delict is, a civil wrong that causes harm. But before a court can ask if a person was negligent or intentional, it has to ask a fundamental preliminary question. Did this person even have the legal capacity to commit a delict? Can a 3-year-old child who breaks a neighbor's window be sued in delict? Can a person suffering from a severe mental illness be held liable for property damage? Today, we're breaking down delictual capacity, or accountability, the rules surrounding minors, mental illness, parent liability, and key case law like Weber versus Santam and Tenna versus UANC. Let's jump straight into it. Let's start with the baseline rule in Zimbabwean delict law. An adult, sane, and sober person is presumed to have the capacity to appreciate the wrongfulness of their conduct and to act in accordance with that appreciation. Notice those two key prongs. Cognitive capability, the ability to appreciate right from wrong. Volitional capability, the ability to act in accordance with that appreciation. If you are an adult, sane, and sober, the court presumes you have both. If you claim you didn't know what you were doing, the onus is on you to prove otherwise. Crucially, determining delictual capacity is a preliminary inquiry. Before you test whether someone acted like a reasonable person, negligence, you must first determine if they are capable of being negligent at all. And how is capacity assessed? Subjectively. You don't ask what a reasonable adult would think. You look strictly at the specific defendant in the exact circumstances they were facing. Similarly, a person suffering from mental illness at the time of the conduct may lack capacity and escape liability. Take note of the authority. Tenna versus UANC, HS 367-81. If a mental disease or defect deprives a person of the ability to understand that their action is unlawful or prevents them from controlling their physical actions, they cannot be held delictually liable. What about a child between 7 and 14 years old? Here, the law applies a rebuttable presumption that the child lacks capacity. However, and write this down in your lecture notes, this presumption weakens as the child gets closer to age 14. To understand how courts handle children between 7 and 14, you must master the leading authority, Weber versus Santam Verzekeringsmaatschappij BPK. In Weber, the appellate division had to determine whether a young boy, aged just 7 years and 2 months, could be found contributorily negligent regarding injuries he suffered in an accident. The court emphasized that testing a child's capacity must be judged subjectively. The court must inquire into the child's degree of maturity, their intelligence and level of education, their personal knowledge and life experience. Now comes the trick question I often throw at students in exams. If a 5-year-old child damages a neighbor's car, is the parent automatically liable just because they are the parent? The answer is no. In our law, parents are not vicariously liable for the delicts of their minor children simply by virtue of parenthood. However, a parent, or a supervisor of a mentally incompetent person, can be held directly liable for their own negligence. How does parent liability work? Failure to supervise. If a parent or guardian fails to take reasonable, diligent steps to prevent a child under 7 or a mentally ill person from causing harm, the parent is liable for their own breach of duty. The Latin maxim, qui facit per alium per se. He who acts through another acts himself. If an adult intentionally or carelessly uses a person who lacks capacity as a tool or instrument to commit a delict, the adult is personally liable for the harm caused. The incapable person was merely the physical conduit. Let's review the main takeaways for your exams. Adults, sane, and sober persons are presumed to have delictual capacity. Children under 7 and persons with severe mental illness, Tenna versus UANC, lack capacity. Children aged 7 to 14 are presumed to lack capacity, but this is tested subjectively based on maturity. Weber versus Santam. Parents and guardians are liable if they negligently fail to supervise or use an incapable person as an instrument. Qui facit per alium per se. That wraps up today's session on delictual capacity on Legal Lens Zimbabwe. Make sure to hit the subscribe button, give this video a thumbs up, and share it with your study group. I'll see you in the next lecture. Until then, keep your legal lenses sharp.